A blessed day to everyone. Magandang araw sa inyo lahat. Para kadigripadak ng Ilocano na nimbag nga aldaw yamin nga pada-pada. Well, this is Court Administrator Raul Villanueva. I am here to make a presentation regarding the guidelines on the submission of electronic copies of pleadings and other court submissions. The reason why I need to do this is because we are already nearing the end of the period within which we are doing, of course, these electronic submissions together with the hard copies of pleadings and other court documents. And once we're done with this period, which is actually from September 1 to November 30, then we have to transition now to the mandatory applicability of the guidelines as, of course, directed by the Supreme Court by December 1, wherein only electronic copies or PDF copies, portable document format copies of pleadings and other court submissions will now be received by our courts from parties and litigants. Take note, in civil cases only. So far, we're talking about civil cases. And of course, we are talking about not only pleadings that are coming in to the court or being filed. We consider this as inbound documents, but court documents, but also those documents that are coming out or will come out from our courts, such as the orders or other notices or even judgments or decisions of our courts. Of course, I am here to just continue the training, supposedly, not only of our judges, but also now of the additional staff that you should be involved insofar as this, of course, eFiling that we usually refer to, or electronic submission of documents, pleadings, and other court submissions. So, and I'm referring, of course, to this additional staff, not only the clerk of court, but also the interpreters and the civil docket clerks. Later on, if the courts would like to add additional staff to be involved insofar as this, of course, electronic filing and service of documents, pleadings, and other court submissions are concerned, then this can be the subject of course, perhaps in the meantime, a case-to-case matter, that will be addressed by the Office of the Court Administrator, and of course, with clearance with the Supreme Court. So let me now proceed first. Of course, like I said, I am referring to AM number 10-3-7-SC and AM number 11-9-4-SC, or which is referred to as the guidelines on submission of electronic copies of pleadings and other court submissions being filed before lower courts, or what we usually refer to as the trial courts, pursuant to the efficient use of paper rule. When we talk about trial courts, we're referring to the second-level courts and the first-level courts. Of course, insofar as the appellate courts are concerned, the third-level courts are concerned, these current guidelines do not involve them in the meantime, because we're talking about civil cases before our trial courts. Very important insofar as this resolution of the court in this administrative matter dated August 20, 2024 is concerned, is the subtitle to this particular court issuance, and that is, we are now moving towards digital courts, which means we are now referring to the component, the first component, or component 1, which is transition to electronic filing and service of pleadings, motions, and other documents, as well as digital service of all orders in civil cases. So I hope if you did not notice it, this is the first component of what referred to as, let me just tell you, the eCourt PH 2.0 or eCourt Philippines version 2.0. And in this eCourt Philippines or PH 2.0, we are talking of 6 components or 5 components. Sometimes the 1 or 2 components are being combined already. But the first one is as provided in the issuance of the court or the administrative matter issued by the court recently, dated, as I mentioned, August 2024, is one, the digital filing and service of all pleadings, motions, and other court documents, as well as the digital service of court orders in civil cases. The second component, if you're interested, and of course you need to know already, is the installation of digital case dashboards in all the trial courts. And of course, the third component is the digitization of existing case records. This is very important. So we're transitioning to a digital court. So this means that we have to digitalize actually our existing records. So why? Because there is a situation right now wherein starting September 1, several months ago, we required that pleadings and other court submissions in civil cases be both in hard copies and PDF copies. So there might be a situation wherein, of course, if not all cases are new by September 1, then you have records that are not in PDF copies that form part of the record of civil cases, no? Wherein we may have a hybrid kind of records wherein there are records of pleadings and other court submissions with both hard copies and PDF copies, and then we have court records that are still in hard copies. So this need to be digitalized later on, and this is something that our courts will have to be ready as well if they have hybrid records, no, starting September 1. And then the fourth component is the digital filing and service before the Supreme Court and of course the appellate courts. When we say the appellate courts, we're talking about the Court of Appeals, the Court of Tax Appeals, and the Sandigan Bayan. But because we're not talking about criminal cases yet, then of course, the appellate court referring to the Sandigan Bayan will not yet still come into play insofar as the fourth component is concerned. The fifth component is the digital appeals process. This is very important. That's the reason why there is a need to require both hard copies and then PDF copies of pleadings in civil cases in our trial courts. And then by that is from September 1 to November 30, 2024. And then by December 1, only PDF copies in civil cases, no, regarding pleadings and other court submissions will be required for submission. And then, insofar as criminal cases are concerned, this will not be covered yet in the meantime. But when we're talking about digital appeals process, that is wherein when we're done with the digitalization of our pending case records in civil cases, no, most especially, then that would enable now our courts to transmit only the soft copies or the PDF copies of their records instead of the hard copies. No? So that's the fifth component. And finally, the sixth component, like I said, some are being combined, no, to make it 5, but based on the resolution in the meantime, it's 6. No? And the final component is the digital criminal and special proceedings. So take note, criminal cases and special proceedings cases will be covered by the mandatory applicability of the submission, no, in PDF copies of pleadings and other court submissions only in the sixth component. So now let me now just go briefly, no, and as fast as I could regarding the salient features of the guidelines, no, as approved by the court last August 2024. So I hope you don't mind. I will not go into the details of each section. I will just try to highlight what I think are more important, no, and for you to remember. But I'm sure, and of course, my presumption right now, by this time, many of you are familiar with the guidelines. But I hope you understand this is being done to comply with the directive, no, coming from the Supreme Court, especially for purposes of certifying that judicial regions are capable already of course, receiving, filing, and receiving pleadings and other court submissions in PDF copies. So this is a continuing process, no? So that's the reason why we have to continue with this kind of training through, of course, this online, no, facility that we're doing right now. So pagpasensyahan nyo na, no, this is, I know that you may have heard this all over and over and over again, but this is something that we have to to carry out, no, in the office of the court administrator, because we are nearing, no, the period within which there is a need for us, no, to certify, insofar as the office of the court administrator is concerned, to certify, no, judicial regions regarding the readiness or preparedness for purposes of the mandatory applicability of the guidelines, no, on the submission of pleadings and other court documents in electronic copies, no. So of course, the Section 1, for example, is the mandatory submission of electronic copies of filings in civil cases. So it's very important, no. The emphasis here is civil cases, and what Section 1 is just saying is that the courts, no court can act on any pleading except initiatory pleadings or petitions, no. For example, motions that are filed in court, pending incidents, no, before our courts, you cannot act on this starting September 1, which you're now familiar with, until and unless you receive a copy of the PDF, no, copies of the same pleading. So take note, it must be the same. The hard copy submitted, for example, a motion, should be the same, no, when the electronic copy or the PDF copy is submitted to the court, no. And when is that PDF copy or electronic copy to be submitted? Within 24 hours from the filing of the hard copy, for example. And the hard copy can be sent in 3 ways. First is by personal delivery. So the party will go to the court, have the pleading mark or court submission stamp received, and you count the 24 hours, of course. For example, if it's received on a Monday and at 5 o'clock in the, at 4 o'clock in the afternoon, so you count the 24 hours the following day, no, at 4 o'clock. That's the deadline. And then, of course, it can be through registered mail, and then, of course, through a private courier, no. Take note, if these are the 2 modes that are used, you will have a situation wherein the electronic copies will come first, will arrive first, no, will be received by your court first before you receive the hard copies, because unfortunately, our mailing system is not as fast, no, as we wanted to, or we want to, especially when it comes to registered mail. But when it comes to, of course, courier services, this is much faster, especially if it's only within a particular town or city. But of course, if it's outside already, then sometimes it takes a little longer, no, than 24 hours. So very important, no, when to count the 24 hours. The receipt in the registry receipt or in the receipt, no, coming from the private courier will be the basis of the 24 hours. But again, like I said, if the documents, the hard copies are mailed, then you can expect that the electronic copies, if the filer, no, will be following the 24-hour requirement, then you may be receiving electronic copies ahead of the hard copies if these are made. But take note, so when do you act on the pleading? Then because the original submission is made through mail, registered mail or courier, then you will have to wait for that hard copy to arrive first, even if there is already an electronic copy on record, no, or on file. So very important for you, of course, to realize that this may happen, no? And take note, very important insofar as this Section 1 is concerned, is that our staff, the clerks of court, the interpreters, and the docket clerk, civil docket clerk, they should continue to monitor now our email addresses. And which email address are we going to use? Remember, so far, right now, we have 2 official email addresses, PJ365 email addresses. One given to the judge and the other entrusted to our clerks of court or the OICs, no? So very important. In the meantime, there will be a sharing, no, among the clerk of court and the court interpreter and the civil docket clerk using the PJ 365 for the courts. Why? Because this is where all the pleadings will be coming in. Very important that they have to monitor from morning, in the morning, first thing in the morning of each working day, and then in the afternoon before leaving the office, they have to check again. Why? Very important. Because for one, our email boxes can be loaded, so much so that if you do not take out these emails that you receive on a daily basis, it might result in reaching the full capacity of that particular email inbox, and it would be difficult for the other emails to come in. And then second, it's important that these are monitored because you have to immediately remove and place the electronic copies in the electronic folders or e-rolios that we usually will now have to create for each and every case. How many folders or e-rolios do you need to create? It depends on the number of civil cases that you have. So if you have like 100 civil cases and then there are new ones coming in, then you have to come up with 100 separate e-rolios or e-folders. So very important. That's why you have to monitor. Why the court interpreter? Because they usually come up with the calendar for our cases, for both civil and criminal cases. So they should be familiar with the civil cases as well. And why the civil docket clerk? For obvious reasons, because they're the ones in charge insofar as monitoring and of course filing all of these civil cases. When we talk about Section 2 of the guidelines, it just reminds everyone that outbound documents pertain to documents coming from the courts. Those, you are issuing notices, those orders or rulings coming from the court. So take note, you have to also not only serve hard copies of these orders and notices during the transition period, which is September 1, 2024 to November 30, 2024, but later on, when it is mandatory already to receive inbound documents from the parties or the lawyers, then the outbound documents coming from the court, meaning us, bringing out, they have to be in PDF copies as well. So during the transition period, you have to do that. And now, during the mandatory applicability by December 1, if that will be decreed already by the court, then you have to also do that, issue the court orders outbound documents through that particular mode, the PDF copies. By the way, when we talk about PDF copies, there are two ways of doing that. One is, of course, you have an application wherein a Word document can be converted into a PDF copy. But that would mean that electronic signatures will have to be accepted. But in the meantime, it would appear that we do not have a policy regarding that one. So that is something perhaps that we will have to defer using in the meantime. Then the other way of doing it is, of course, you print out the document and then you scan and then you save it and then you send it. Then in that particular case, that would require you first to print it out. And then wet signatures are still required because we do not use electronic signatures in the meantime. So the wet signatures of our judges or even our clerks of court who sign these documents or outbound documents, then this should be done in the meantime. And very important, when it comes to the electronic documents coming out, you will have to use the email address of the lawyers or the law firm for that matter, if a party is represented by a law firm. Very important. When it comes to the email address that is required from our lawyers, they have to use one professional email address. They're not allowed to use, for example, one email address in Luzon, in a case in Luzon, and then another email address in Visayas, and then another email address in Mindanao. That is not allowed. As far as possible, they should only be using one email address. And the same when it comes to our law firms. They have to make sure that they will use only one email address for purposes of all their cases nationwide. No, it cannot be, one email address for every case that they have. So very important. No. So now, insofar as these guidelines are concerned, very important for you to know as well that Section 3 of that particular guidelines require that December 1 would be the effectivity of the use of these electronic copies and other submissions. So very important. By the way, we have a microsite in the Supreme Court wherein you can have access to information regarding e-filing. But what you usually see will be, of course, when you go to the microsite, you will see infographics, so to speak, about the e-filing guidelines. And it will usually say to you that step 1 is to scan, and then step 2 is to save, and then step 3 is to send. And then, of course, there's a QR code wherein you can find the guidelines, the text of the guidelines. So when it comes to mandatory electronic filing and service, that Section 3, very important. We're talking about December 1. And when we talk about December 1, that means that the court approved of course, the regions, practically if all the regions to be competent for purposes of electronic filing and service of pleadings and other court submissions. So very important. We're looking at December 1 insofar as that is concerned. And again, initiatory pleadings like complaints, petitions, in the meantime, will still require hard copies to be submitted. Why? Because, for purposes, for example, of acquiring jurisdiction over the person of a defendant, if there are many defendants, it is not the court that will, if you will only allow electronic copies, it's not the court that will print all of the copies and the attachments for purposes of serving the summons. That's the reason why this should be, the number of hard copies should be dependent on the number of respondents or defendants. But very important, it is insofar as once hard copies are filed, all subsequent pleadings, even answers, are supposed to be in it should contain already PDF copies, But later on, like I said, you have to have this hard copy of the petition or complaint, initiatory pleading, to be in PDF copies for purposes of creating the electronic folder. So very important. And the email address in Section 4 that is being mentioned, I already started at least telling you that our courts have official email addresses, and they can be all the email addresses that were distributed to our courts nationwide. These are contained in the website of the Supreme Court. The parties can look into that website. That's HTTP. I think if you're familiar with the website, the sc.judiciary.gov.ph, and then court locator / court dash locator. Anyway, I'm just saying that for you to be informed that the parties, if they ask, how can I find out where is the email address of, for example, branch 10 in Cagayan de Oro, it's in the website, okay, as contained in Section 4. So very important for you to always be ready to answer possible questions regarding where to look for these email addresses. Please bear with me because this is something that we need to do in the Office of the Court Administrator, and for you to participate in by listening in and of course remembering what this issuance of the court is all about regarding electronic filing and service of pleadings and other court documents. When we go now to Section 5, of course, the lawyers, like I said, they need to only submit one official and professional email address. There should be this should be a valid email address that can, of course, send out documents and, of course, receive at the same time documents sent through email. And of course, the lawyers are mandated not to submit their email addresses already, and I think you should be requiring them to also do that. For the parties, these are those that are being represented by our lawyers. It is optional, but it is encouraged, no, for purposes of notifying them as well, no, of what is happening, especially open court orders, no, that were issued by the judge, no, and take note, electronic carbon copies. When you talk about this, electronic CCs, no, then the parties should be able to furnish copies of their pleadings using the email addresses on record of the adverse party or the opposing counsel. And likewise, if they use an email address that is not the official email address, that is considered as not filed. Likewise, if documents are sent through and the documents sent could not be opened, it's encrypted, there is a password regarding that document, that's considered as non-filed. No? By the way, what happens if the 24-hour period, no, is not complied with, no, faithfully? Do you end up, does the judge end up or can it already act on the pleading and, of course, deny it for non-filing of the PDF copy? The answer is no. Instead, because there is no sanction in the guidelines, no, regarding such failure. But what we encourage you to do is remind the parties, to the lawyers most especially, to submit these PDF copies so that the court can act on the motion, for example, that was submitted, no, wherein the hard copy is already with the court. So very important, no, insofar as that is concerned. And again, there is an obligation on the part of the lawyer to monitor in the same way that we are monitoring our email addresses through our clerks of court or OICs, and then the interpreters and the civil docket clerks. The lawyers, on the other hand, they should also make sure that they are able to monitor their inboxes, no? Otherwise, email inboxes. Otherwise, they will suffer the consequences, especially if pleadings, no, and other documents have been filed, no, through their email addresses. Now, with respect to Section 5, I'm done already with that one. I think, well, the directory is there. Instead of Section 4, it's in Section 5, just so that to put it in its proper context. No? And then Section 6 and 7 are very important sections. Why? Because this now talks about the requirements for purposes of making mandatory the submission and transmission of pleadings and other court documents, including for both inbound and outbound, no, documents, especially starting during the transition period, September 1 up to November 30, and then December 1 onwards. So this will only happen if there is a certification of the judicial regions, no, that are ready for electronic filing. And in connection with this one, I think many of you are familiar that we already sent out the issuances and directives to our executive judges to already do a survey, and the deadline is already in a few days, and it's necessary that this survey be done not only by the executive judges but also by the interim regional court managers, because this will now serve as basis for the Office of the Court Administrator to submit its report to the court hopefully before November 30, so that they can act on it already. So very important for the compliance of everyone to make sure that you reply to the survey and submit to us the documents that are needed, no, or the data that are needed insofar as the certification required of the Office of the Court Administrator is concerned. So very important. Section 7 tells you what are these what are these conditions, no, for purposes of the Office of the Court Administrator being able to certify whether a particular region is ready for electronic filing, no, and service. Well, one, of course, there is necessary infrastructures already provided. Again, let me just repeat, I've been saying this to many, of course, forums, and of course, during seminars, during even conventions, that when it comes to the IT infrastructures, the procurement has been done already. There is a distribution list. Of course, not all will be given the IT equipment, all the IT equipment that they need, new ones, no, for that matter. But definitely there will be sufficient number. There will be a sufficient number, of course, that will receive 3, for example, 4, and some will have to start receiving only 1 in the meantime because they're not included in the distribution list. But we will include them in the repeat order. There is only the need to determine the ID device, number of these IT equipments that will be delivered by the winning bidders, and of course the installation of the systems, no, that the MISO would like to put, no, in the computers. This will hopefully be done in a short period of time, not too much to delay, no, the distribution. But very important for us to do that, because we cannot just deliver to you computers without the systems and without identifying the ID of device, no, for that matter. But so long as in the meantime, so long as you have existing computers that can receive, that have PJ365 accounts installed, or can accommodate the PJ365, you can receive emails and you can send out emails, then that is substantial compliance in the meantime, insofar as the necessary infrastructure is concerned. Of course, for purposes of complying with the directive of the court. Likewise, there should be sufficient training, no, of the personnel, and this is what we're doing. We have done that already in the past. In August, we have done that already. We have done that later on during this transition period in many of the conventions, in many of the enhancement programs that are being done through the PILJA, no? And we are doing, our justices are, going around the different regions. They have assigned regions for purposes, no, for purposes of doing, no, the training. So everyone is doing, no, its share, no, his or her share, sorry, insofar as the training is concerned. And this is part of it. No, that's the reason why later on this will be uploaded to be able to cover as many, no, as we could for purposes of the training that is required about the issuance of the court, no, on electronic filing and service of documents and other court submissions. And then the other one is that the judges are capable already of course, coming out with their orders, coming out with decisions using the electronic copies of the folders or the e-folders. Very important that you should now be trained, no, for that purpose. And we know that you can do that. Of course, what will be required now, the procurement that we were able to already finish covered the purchase of laptops, no, that we expect will be distributed to our judges. So you have the old laptops, you can use the new laptops for purposes of having the folders in one laptop perhaps, or one screen, and then doing it in your other device. No? So very important that you should now be able, no, to do that. And then finally, of course, there is an amendment that requires that needs to be done with respect to Rule 13 on the service of pleadings and other court documents, because in Rule 13, it speaks in the meantime of personal service. It talks about registered mail. It talks about couriers. Of course, it talks about electronic means. No? But now, if there is a need to amend Rule 13, it will have to do away with some of these modes for purposes of making mandatory the use of PDF copies for purposes of filing and service, no, of pleadings and other court documents. So these are the requirements. First, I will just repeat that later on, but that's Section 7 for all of you. Now, going to Sections 8 and 9, these are the instructions to the filers. So these are not, but this should be familiar, no, to our staff. Why? Because this contains, for example, the subject, the body of the pleadings. There is, of course, a cover page, no, mentioned in the Section 8 and 9, wherein they should comply with respect to, for example, they should always indicate what is the primary mode of filing during the transition period. Personal delivery or registered mail or courier. It's important. It's indicated there so that the court will be able to determine whether or not the hard copies are in already, and second, the period within which to file, no, to reckon the 24-hour period. So very important yan. And of course, the naming of the documents when they need to submit documents. What is the first document that the first file that they will submit is the main document. For example, a motion. That's the first thing. And then if there are attachments to the motions, that's the second file, no, that they will have to transmit. So very important, no, that you should be familiar that what is required of our filers is that when they file the electronic copies, the PDF copies, they have to separate the main file, which is the pleading itself, and then motion, for example, or manifestation, and the second file and so on should be the attachments. So if the attachments are too many, then they can divide it into batches. No? So very important for you to know that. But that, like I said, is an instruction to the filers, Section 8 and 9. The lawyer should be familiar with that one. The party should be familiar with those kinds of no? And formats. No? Section 10 is about proof of electronic transmittal. I think I mentioned that already. When do you count the 24-hour period? Remember, it depends on the primary mode of filing. So if it's personal delivery, the date and time stamp would be the reckoning period, no, for the 24 hours. When it comes to registered mail or courier, you use the receipts for purposes of determining the 24 hours. The digitization training for court personnel, I think that is what we're doing already. That's Section 11. And then public access to court records. Of course, this would require, no, because one of the requirements under Section 7 is that we are able to come up with the website, no, to enable access, no, to the records that have been electronically filed. So that is in effect, no, public access to the court records of the parties, no, involved in the case, no, the lawyers and the parties. But take note, when it comes to the public itself, we have to, who are non-parties, it's very important that this be the subject of request, no. It cannot just be given out because there must be a reason, no, for that. What if the parties, the concerned parties, the interested parties would want to have the records, no, on file photocopied? Then this is something that you don't need to bring. Unlike before that you have to take out the records and then go to a Xerox machine, no, for that purpose. Now it can be the subject of just giving them through emails, no, the electronic copies if you have the electronic copies, no. So very important, no, why we're leading towards that. It's going to be a paperless kind, no, of court. But of course, in the meantime, we have to still until like I said earlier, until we use the e-signature, you have to just print, and then the wet signature should still be affixed, and then you scan it and then save it, and then that's the time that you send the PDF. No? Very important in the meantime. But later on, I'm sure we'll come up with the capability and the process, no, the procedures, no, regarding e-signatures. And then electronic first resolution. Like I said, this is something wherein the judges are supposed to make sure that they're capable already of not relying on hard copies of the court documents when coming out with their orders or decisions, but through the use of the electronic folders. The other provisions on technical support, I think that is where the Supreme Court Management Information System Office has a big role, including, of course, involving in training, especially very important, no, about the creation of folders, about putting in, PDF copies of files that were filed, no, for a particular day, and then putting it in the electronic rolio. So these are the technical aspects, no, that largely, no, the MISO, no, should take care of. And we have requested the MISO, no, in connection with that one, to come up with similar videos, no, instructional videos about this particular matter, because the technical aspect is one that will, we do understand, pose a challenge, no, to everyone. But we need to learn how it is done. That's why the clerks of court are involved, the court interpreters are involved, and the civil docket clerks, no, at this point in time. Of course, the procurement of the IT equipment, like I said, we are already done. It's just a matter of delivering them based on the distribution list that we have, and then we will have a repeat order. And then we are already embarking on the procurement of another set of IT equipments worth perhaps another 1 billion, so that we can deliver as many as we could. So please bear with us, because for the past several years, because of the pandemic, we hardly had procurements, no, of IT equipment, simply because it was difficult, no, for more than 2 years, no, to be able to do that. We had to do biddings online. It's so difficult because documents are not being submitted. Physical copies are being submitted, but the parties could not even come to us, and then they have to join us through video conferencing for purposes of even the pre-bid conferences and all other stages, no, of the bidding process. And of course, data privacy, we are respecting that as provided in Section 17. Insofar as data privacy is concerned, the guidelines speak only a little of it, because what is important now is for you to be familiar with the fact that our executive judges, no, and there are a number of executive judges that have been now designated starting last November 1. They serve, no, as our data privacy officers insofar as our various courts are concerned, no? And that's very important, that for you to be familiar with the fact that we observe, no, and comply as much as we could insofar as data privacy is concerned. And of course, Section 18 is all about just repealing the previous issuances of the court on electronic filing. Before, small claims were not included, no? Now, because there is no mention in the resolution dated August 2024, then it means that electronic copies of pleading should also be submitted by the parties, no, in small claims. But to me, the initiatory pleading need not be an electronic copy, but of course the reply, no, the form reply will now have to be also in a PDF copy. And that's where perhaps in the meantime, our staff should assist the parties, because we know that parties in small claims cases are not represented by counsels. So if they need assistance, then we have to provide that assistance to them in the meantime. Okay? So let me now just go to the frequently asked questions quickly. Number one, of course, this is covered, no? This is covered by OCA Circular number 272-2024, dated September 6, 2024. So we have come out with these frequently asked questions, but take note, there is a platform where additional questions may be asked. If there are some that have been have been sent there, then we will endeavor to reply, no, to the questions. But in the meantime, we would just like to share with you what have been included, no, in the frequently asked questions in OCA circular number 272-2024 dated September 6, 2024. So for example, are all cases covered by the guidelines? The answer is no, because we're only talking about civil cases. And these civil cases include those governed by the rules on summary procedure and small claims cases, as well as special civil actions. Special proceedings, obviously hindi, because it's in the 6th, di ba, component, no, of the e-court PH 2.0. And when will the mandatory electronic filing and service start? I think that's already discussed, September 1, 2024. In the meantime, that's a transition period up to November 30, 2024, wherein hard copies are filed and then electronic copies or PDF copies are also submitted within 24 hours. How will the 24-hour be computed? For the purpose of sending electronic copy of the filed pleading, I have mentioned that already as well. If it's personal delivery, then we know what is stamped in the pleading. If it's personal, if it's registered mail or by accredited courier, then it is based on the receipts. No, if it's electronic, if the agreed mode of filing is electronic filing, then obviously you don't need the hard copy anymore, and the basis of the filing is when it is transmitted to the court. By the way, if that is the case, if it's the principal mode, especially December 1, if it becomes mandatory, when is the deadline of a particular pleading? Take note, if it's purely electronic, then the deadline, for example, if the deadline is today, then the time that this pleading can be submitted is up to 11:59 of short of midnight of today, no, the same day. So very important, no, na yun ang ano, no, impact, no, ng electronic transmission na lang, no, ang mode of service. Question number 4, where can we find the email address of the court? I think I have mentioned that already, no. It's https://sc.judiciary.gov.ph/court-locator, then another slash. Number 5, what happens if we fail to send an electronic copy of the pleading? There is no sanction, like I said, but the court cannot act, no, on a pleading, no, the hard copy of the pleading without the electronic copy. Question 6, which email address should be used to send electronic copies? Obviously, the official email address of the court, no, and then for the purpose of the lawyer, no, and the party, it should be the official email address of the lawyer. What happens if the electronic copy, question 7, is sent, no, using a different email address from that of record? For obvious reasons, it's considered as non-filed. Question 8, how should we notify the court of our email address by way of a notice of appearance? Of course, if the counsel is appearing for the first time. But if the counsel has already appeared for the first time, especially if the case was filed before September 1, 2024, I think a manifestation would be sufficient. But of course, if they want just to be sure that the correct title of the pleading is filed, then a notice of appearance / manifestation for purposes of indicating the email address of the lawyer. Number 9, what shall the notice of appearance contain? Well, obviously, the basic information should be that of the email address. Question 10, when should the notice of appearance be filed? Of course, from here on, that should be the email address, no, should already be known to the court. Question 11, what will happen if a notice of appearance is not filed? Well, for purposes of the outbound documents, there is a waiver, no, on the part of the party who did not submit the email address in receiving, no, these electronic copies of the outbound, no, court documents. Can we modify, add, or delete email addresses of record? You know, this will have to be on a case-to-case basis. But as far as the court is concerned, the directive is only one email address should be used. If there is a need to change because there is a threat, because an email address made known to the public may be used, no, to send threats or any kind of matter, no, that may cause a lot of inconvenience, no, to the owner of that email address, then it can be submitted to the court for consideration. But take note, once you remove an email address, perhaps that will happen to every case, no, that lawyer may be handling. Question 13, when should the sending an electronic copy of the pleadings to the opposing party, of course, the requirement is the electronic CC, electronic carbon copy, should indicate the email address of the other party. So that is the time, no, when you send out the pleadings, and then you send out the PDF copy within 24 hours. It should already contain the electronic carbon copy. Question 14, what is the proper format for the transmittal of the email subject? Take note, this pertains to the instructions, no, in sections 8 and 9 of the guidelines, which I told you already is actually what the filer, no, the lawyer or the party should be familiar with, no. So the civil case number should be indicated there, the parties, no, to the case, and what is the pleading, no. If it is a complaint, if it is a motion, so that will be indicated. Case number, the parties involved, separated by hyphens, and then the pleading, no, that was filed. And then when it comes to the email body, so this is very important, but it contains a lot of information. It talks about the docket number, it talks about the case title, it talks about the name of the filing party, it talks about the contact numbers and the email addresses and the list of the documents, no, attached to the document that was filed. And again, I have to repeat that the first item or the first file that should be submitted or sent through email by the filer should be the main pleading. And then the other items, the next file should contain the annexes if there are annexes. And then if it's a large document, then it can be sent in batches. Question 16, which attachments shall be included in the transmittal email? Of course, the attachments, no, if there are any. In what other section, question 17, in what other instances are electronic submissions deemed not filed? Well, of course, the PDF files have passwords, the electronic copies are not in PDF, obviously, and then the PDF file is embedded with codes, and it cannot just be opened, no? So basically, those are considered as not filed. And what do you do insofar as that is concerned? You better inform through email the party, no, that there is something wrong with what they submitted. You cannot just keep quiet. But the whole point is, because this is something that we have yet to perfect, then there is a need for us to be able, not to collaborate, no, in so far as making it work for not only for the courts but also for the parties as well. Is there a limit to the size of the PDF files to be submitted? That's question 18. There is none. You know, our email addresses can receive as many emails in a day. But that's why. But you know, it can be loaded. That's why you have to take it out, bring it to our cloud, no, bring it to our storage, no, for purposes of unloading the declogging, no, so to speak, or increasing, no, the capability of the email to receive more documents if you take out those that have already come in, and then you just place all of this in the separate folders, no, that you have created for each civil case that you have. Question 19, are scanned copies of physical documents converted to PDF allowed? Like I said, no, the scanned copies, that's one way, no, of making sure the PDF copies are filed. So the application to convert Word document into a PDF copy, that is something that we cannot, no, and at the meantime process, for the very simple reason that it might contain electronic signatures, which we do not have, no, a policy yet in the meantime. If there is a discrepancy between the scanned copies and the machine-readable text generated by optical characters, no, in an application, so which one will prevail? The scanned copy, for obvious reasons, because that's the one that we recognize. Question 21, what is the file name convention for the PDF? Like I said, the file name convention based on sections 8 and 9, the case number, the title, and the pleading, no, the nature of the pleading, if it's a complaint, if it's a motion, and the like, no. Question 22, what is the file name convention for additional documentary accompanying the main pleading or court submission. Like I said, you first file the major document, and then the next one would be the attachments, no? So and whatever designation, no, insofar as that document and the folder, no, is concerned. The file name, of course, will depend on what is the case number, the parties to the case, and of course the nature, no, of the case, no. So that will be the main file name for purposes of our courts. What if the attachments exceed the maximum size allowed by the small service provider? Take note, it can be done through batches, no? So they just have to identify that the second file that was filed was batch 1 of 3, for example. Question 24, should the filing party or counsel retain the original paper document electronically transmitted? The answer is yes. In the meantime, why? Because it might be the subject of comparison. So very important yan, no? That the counsel keep a copy of their original document or hard copy in the event that there is a need, no, to either resend or even compare. No? What happens if the primary pleading is correctly filed but the additional accompanying documents were not transmitted? No? Then the additional accompanying documents should be resent because the original, the pleading, no, the first file was successfully transmitted. What if it was the attachments that were successfully transmitted and the main pleading was not? Then you have to inform the party because you cannot act on that particular pleading without the main pleading having been transmitted as well through electronic means. Is there a sanction for filing PDF copies incorrectly? Yes, in a way, you can fine the judge can fine the counsels, no, for that because it delays action insofar as the pleadings are concerned. Question 27. If there is both physical and an electronic filing of a pleading or other court submission, which copies shall be controlling? Well, if the primary filing is through the hard copies, then that should prevail, no? If it's through electronic means, then the electronic copies will prevail, no? Question 28, what happens if there is a material discrepancy between the paper copy and the electronic copy? Well, then you will have to take into consideration first during the transition period the paper copy. And what, of course, when it becomes mandatory for electronic copies to be submitted, then it's the electronic copy that will now be the only pleading to be considered. Question 29, should we keep a copy of each transmittal email? Yes, of course. No? Insofar as the court is concerned, later on, we will do away with that. But in the meantime, yes. Why? Because that might be the subject of comparison as well. What happens if counsels and parties are not able to check the inboxes? Well, then that means that they will have to suffer the consequences. Like I said, they can also be sanctioned, no? Especially the parties for failing not to do that, no? The court may, of course, let them just suffer the consequences if that is the case. Sometimes, no? Question 31, can the requirements for electronic submission be waived? Well, there are two instances wherein electronic submission cannot be made mandatory. One is because the document cannot be converted, no, into PDF copies. Like, for example, perhaps object evidence, although photocopies perhaps can be taken, and then for purposes of just transmitting, the photos will be transmitted, and then comparison can be done during the trial, no? Including even documents. So sometimes there are judges who are asking, how can we compare now documents that have been marked during trial, especially during the testimonies of the witnesses? Then you just during the hearing, you can note the documents that were marked or remarked, and then during the offer of evidence, that's the time, no, that the offered documents in electronic copies will now be the only documents that you will consider and not the previous markings, because what will control is the formal offer of evidence. So, question 33, I am not a party. Do I have access to the electronic case records? Normally, we always say that our records are of public in nature, but take note, not everyone can just have copies of our record. Because, like I said, sometimes there might be some data privacy concerns there. But more importantly, there must be a reason why parties would like to get hold of our records. If it's especially because we're trying to avoid, these records being used, for other purposes. Question 34, we're nearing already, konti na lang. Can we request for electronic copies of case records filed before September 1? To my mind, because we will eventually move towards digital appeals process, and for purposes of completing your rollo, to my mind, that should be something that we should already look into and work on. Question 35, how will we receive court issuances during the transition period? Well, like I said, September 1 up to November 30, both hard copies and PDF copies, if hard copies are still being required. If there is an electronic transmittal only agreed upon by the parties, then that is something that they will have to comply with already. Question 37, when will the transition period for the mandatory electronic filing and service end? November 30, like I said. If we're able to certify the regions that are prepared already for electronic filing, then December 1 will be the start of the mandatory applicability of the guidelines. Question 38, after the transition period is over, what is the effect of the receipt of electronic copies? Well, after the transition period, the inbound and outbound court documents shall have the effect of initiating or tolling the period for filing among others. So, meaning, of course, the documents that will toll the running of any period will be the document that will be submitted and allowed to be submitted in court. Are the guidelines subject to the rules on data privacy? I think I've mentioned that already. That's question 39. Like I said, yes, indeed, there is a general provision regarding data privacy. But of course, the specifics more or less pertain to what the law prescribes, that we try to avoid as much as possible violating the rights to data privacy of individuals, parties who have cases before our courts. And finally, question 40, where can we course our questions about electronic filing and service? There is an email address for this one, or a website. That's tech.support.spji@judiciary.gov.ph. So I think that's about it insofar as the frequently asked questions are concerned. My final perhaps slides for all of you is with respect to the checklist for pleadings and other court documents. These are based on the provisions of the guidelines. I will just share them with all of you because these are just checklists from September 1 to November 30, 2024. But once there is already mandatory applicability of the guidelines, then perhaps the checklist will only be limited to electronic copies already and no longer with respect to hard copies still being filed. So I guess that's about it. You can just look into the guidelines. I will just share them with all of you as part of my presentation. So finally, Section 7 again, the requirements for certification. That's something that we in the Office of the Court Administrator are actually directed to work on, and that is what we're doing right now. And hopefully, this part of the requirements will already be enough to cover as many as possible with respect to the judges and the staff who should participate and be involved insofar as complying with the mandatory electronic filing and service of pleadings and court documents, both inbound, coming into the court, coming from the parties and the lawyers, and those outbound, coming from the court, meaning issuances from the court, like orders or even judgments and rulings. So I guess that's about it for me. I thank all of you for your kind attention, and I hope that you realize that the Supreme Court is really bent on transitioning already to a paperless kind of court, an e-court system wherein technology forms a very big role. Plays a very big role insofar as our court processes are concerned, particularly in civil cases. In the meantime, in connection with our efforts, no, to see to it that all the components, no, of the e-court PH 2.0 are accomplished, so that in the end we will have this digital, no, court system, no, envisioned, especially by the Strategic Plan for Judicial Innovations 2022 to 2027. So with that, maraming salamat po sa inyong lahat. God bless all of you. And of course, we plead to all of you to please, no, make sure that we all are on the same page, no, insofar as this initiative, no, of the court is concerned. So mabuhay po kayong lahat.